Good morning, ladies and gentlemen, et bienvenue à la commission.
Welcome to the Standing Committee on Justice and Human Rights.
12. We have before us an act to amend the criminal code inflicting torture, the proposed bill C-242. I'd like to take this opportunity, as we have some members that are substituting this morning that haven't been with us before, to welcome, Ms. Stubbs is here, and Mr. McCauley, and Ms. Hardcastle, and Mr. Rusnek. It's nice to have all of you here. I'm sure you will very much enjoy our witness, Mr. Fragiscatos. And Mr. Fragiscatos, it's a pleasure to have you here as well, although you subbed on the committee before. But we're very excited to hear from you on your bill, so I'll invite you to make opening statements.
Thank you very much, Mr. Chair. Thank you, colleagues. It gives me great pleasure to appear before you today to formally address my private member's bill, Bill C-242, an act to amend the criminal code inflicting torture. It is humbling to see the bill reach the committee stage, and I would like to make it clear from the outset that I am willing to enter into a dialogue that will make the bill stronger and more legally palatable from your perspective. As stated in the House of Commons earlier this spring, I am open to a range of amendments and encourage the committee to make any suggestions that they believe will improve the bill. Furthermore, should you require clarification as to why I chose a certain direction, please do not hesitate to ask following my statement. I am not an expert lawmaker. However, I did a great deal of research and consulted widely prior to tabling the bill that has come before you today. I also taught human rights policy at the University of Western Ontario prior to becoming an MP. It was there that these sorts of issues were first encountered by myself and inspired the bill. Part of my PhD thesis also focused on issues of torture, hence my interest in the issue. With that said, after being drawn 9th in the private member's bill lottery, I felt a responsibility to take advantage of this good fortune by putting forward a meaningful reform. I might have sought for a particular cause to be given special recognition or to have a forgotten historical event commemorated. Such initiatives certainly have their place. Yet, I felt the need to go in a different direction. Article 5 of the Universal Declaration of Human Rights states, quote, no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Thankfully, Canadian law does not ignore this principle. A torture offense exists in Section 269.1 of our criminal code. The problem, however, is that 269.1 only applies to state officials. Examples include police or military personnel who might inflict severe pain repeatedly and over a prolonged period of time to intimidate or to coerce as a way to extract information or for some other purpose. Yet when the same actions are perpetrated by private individuals who have no tie to the state, the offense is usually called aggravated assault. As many of you are already aware, kidnapping is also applied as a charge. Assault with a weapon or forcible confinement are other possibilities as well. Some detractors believe these charges are good enough. They believe that though torture committed in the private realm can happen, the problem is in fact exaggerated. I would respond to that criticism by saying, tell that to those who have endured torture. I will only point to a few examples. There are many others that have occurred in recent years. The details, while difficult, are extremely important. In 2006, a Calgary man was made to take off his clothes and had his hands and feet tied with cables. He was then left to hang from the ceiling joists while his torturers punched, cut, and whipped him with a belt before spraying him with butane. This happened over a period of days. 2 individuals were found responsible. The first was a youth who could not be sentenced in adult court. The second pleaded guilty to assault with a weapon and received a 2-year sentence for what amounts to an example of torture. In 2008, a Brampton man had his toe cut off, was beaten with a bat, cut multiple times with salt rubbed in his wounds, and had a plastic bag put over his head. This took place over several hours and seems to have been done with the intention of obtaining information about a theft. The individual who carried out the action was found guilty of aggravated assault and forcible confinement and given a sentence of less than 10 years. The more appropriate word choice would have been torture, because that is exactly what took place. In fact, the judge used the word torture to describe the victim's experience. In 2010, Dustin Paxton beat, starved, burned, and cut off the lip and part of the tongue of his victim in a well-known Alberta case. This seems to have happened for perhaps as long as 2 years. While a dangerous offender designation was assigned by the courts, Paxton was charged with aggravated and sexual assault, even though torture more properly captures what took place. The need to call crimes what they are is not simply an academic matter. In order for victims to heal, their suffering must be acknowledged. This is a long-established human rights principle. Indeed, this lesson underlined the Truth and Reconciliation Commission process on residential schools. Using terms such as aggravated assault does not adequately speak to the grave human rights violations that have been committed. Finally, some criticize the bill because it calls for a sentence of up to life imprisonment, while the existing state torture law only offers a maximum of 14 years. It is true that this is inconsistent, and I believe strongly that a much stiffer sentence for acts of state torture is certainly warranted. However, I'm extremely open to suggestions and amendments to this specific sentence that would make the bill more legally responsible from your perspective. Thus, rather than aiming to do everything and as a result accomplishing nothing, I place my focus on a gap that has been almost completely disregarded by Canadian legislators until this point. I did so after consulting with victims, their families, and civil society organizations. I also worked through various drafts and continuously consulted with the Department of Justice. This legislation was drafted by expert bureaucrats trained in the law. I value the support they provided and the passion they show for their work each and every day. The world is shaded in gray, and so too is most legislation. Given a choice between ignoring an unjust status quo or changing it imperfectly, I opted for the latter. Tortures aim to rob individuals of their dignity. They do so through the intentional and repeated infliction of severe pain, suffering, and humiliation over a prolonged period of time for the purposes of intimidation or coercion. These actions have no place in a free and open democratic society such as Canada. Furthermore, it is true that torture, from an international legal perspective, has traditionally been understood as a state crime. I acknowledge that, I respect that, but add, crucially, that the definition has indeed shifted. The Committee Against Torture, which is responsible for monitoring the UN Torture Convention, has said that torture in the private sphere qualifies as torture. This view has been accepted by other states. The proposed legislation shares much in common, with existing torture laws in Australia and France. Both countries, extremely important allies to Canada, have strong torture laws that apply to state and private actors. Canada should follow suit. Recognizing such a change would acknowledge the ordeal experienced by those who have suffered torture and punish torturers accordingly. Cases of extreme violence and inhumane conduct have happened in Canada and could take place again. It is time to act and make positive change happen. With that said, in addition to receiving support from an abundant number of individuals, colleagues from various parties, and groups from across Canada, I would like to highlight a few truly significant national endorsements that Bill C-242 has received. The Native Women's Association of Canada, the voice for Indigenous women and girls in this country, has offered their full support for the bill. Amnesty International has committed their support in principle for what Bill C-242 is trying to achieve. They also firmly condemn torture in the private sphere. The Canadian Nurses Association of Canada has endorsed this proposed legislation. The CNA is the national professional voice of nearly 139,000 registered nurses across Canada. And the Canadian Federation of University Women, representatives who are here today, a nonpartisan, equality-seeking, self-funded organization of close to 9,000 women in 112 clubs across this country, has committed to being a fervent advocate for this proposed legislation. Furthermore, I would like to thank the residents in my riding of London North Centre for their unwavering support. I have heard from my constituents and recognize their desire to see this proposed legislation succeed. The support of the London Abused Women's Centre and its director, Megan Walker, is extremely and sincerely appreciated, as is the support of the Chief of Police Services in London, John Perry. I thank them both very, very much. With that said, I would also like to commend Linda McDonald and Jean Sarson from Nova Scotia, who will appear before you shortly. These two women are staunch advocates for the inclusion of torture in the private sphere into the criminal code. They have worked for over 2 decades to advance this important cause, not just in Canada, by the way, but in the international domain as well. Once again, this is not a perfect piece of legislation, but then again, I am not sure if any piece of legislation is ever perfect. However, I am open to any potential amendments suggested by this committee. This would include lowering the term of punishment. It would be a sincere shame to have this important bill defeated because of concerns related to technicalities that could easily be altered. I ask my colleagues here today, when reviewing this bill, to ask yourselves the following questions. Do you believe that human rights matter? Do you believe torture has no place in our society because it robs individuals of their humanity and of their dignity? Do you believe the way to enhance public safety is not by building more jails or through the politics of division and fear, but through enshrining human rights principles into the law, into our criminal code? If you answered yes to these questions, then we must work together to ensure that Bill C-242 is strengthened and referred back to the House for further consideration. To conclude, this bill is not about me. It has never been about me. I dedicated the bill to all victims of torture when I first put it forward, and that has not changed. To them I say, your voice matters. I have listened to you and am working and willing to do whatever is necessary to ensure this bill continues to progress. Thank you very much, colleagues.
Thank you very much, Mr. Fragaskatos, for your very passionate and very coherent remarks.
Thank you.
And now we'll move to questions. We're going to do 2 rounds of questions. So the first round is going to be started by Mr. Falk. Mr. Falk?
Thank you there, Mr. Chairman, and thank you, Mr. Fragaskatos, for coming to committee and for the work that you've put into preparing this bill and presenting it.
Thank you, Ted.
I think you've touched on something that is it's a very important issue, and it's probably not lost on any of us. I guess when I look at the bill, I have a lot of questions, and I don't know if you'll get a chance to answer all of them on this first round. But I guess I'm wondering. Well, first of all, I'm wondering if you've had any personal experience yourself with torture.
Yeah. I have not. As I alluded to at the outset, I first became aware of this gap in the criminal code, the fact that acts of torture that are carried out in the private sphere are not recognized as torture in our law. I first became aware of that when I was teaching human rights policy. I certainly consulted with victims on this. You might wonder why victims aren't speaking. I think one of the reasons that victims have had a difficulty coming forward is the experience. This experience is quite traumatizing, as you would well imagine. It's traumatizing, it is scarring, and it's been very difficult for victims to come forward. I think Jean and Linda, when they speak, will testify to that fact. But I do not have personal experience with torture, no.
Okay, good, thank you. The other thing I'm a little curious about is you've cited several examples of instances where Canadians have experienced non-state torture. And where they've been charged under a different under our existing criminal code. Mm-hmm. And I'm wondering, if your legislation had been in place, what difference would it have made in the sentencing, in your opinion? Would it have made a difference? Would the sentencing have been the same, or would it have changed things? Because I don't see in your bill anywhere where you're suggesting any minimums. But in fact, at the moment, you're suggesting a maximum life sentence. Mm-hmm. So it's and you've already identified that you're willing to consider that term as well. But can you tell me, in your opinion, what difference you think it would have made in the cases that you cited?
Sure.
Yeah.
I take my cue from victims. I take my cue from their experience. And this is all a matter of perspective. In fact, I think it's safe to say that law is a matter of perspective, certainly when it comes to these sorts of difficult issues. And so the perspective that I bring to this is not the perspective of someone who taught human rights policy. It's not the perspective necessarily of an MP. It's the perspective of someone that takes very seriously the victim experience. The philosopher Theodor Adorno said that the condition of truth is allowing suffering to speak. And so when you ask what difference would it have made, I think, and I know because I've spoken to so many victims, that it would have made a huge difference for those individuals. When the term aggravated assault is applied that describes their experience. But the term aggravated assault can also be used to describe a fistfight. That is not appropriate. What these people have endured in the examples that I gave, Ted, and in the many other examples that exist, is torture. We need to call crimes what they are. We need to acknowledge that experience. When we do, healing can begin.
I appreciate that because you've actually answered the next question
No.
that I had, which is
Glad
what
to do it
difference
for you.
what difference would it make to the victims
Yeah.
is the question I really wanted to get to eventually. But I'd like to go back to the question I asked. When it comes to sentencing,
Yes.
what difference do you think it would make? I understand that from a victim perspective, the acknowledgement of what actually happened is important. I get that, and I think you're right. But I'd like to know, from a sentencing perspective, what difference do you think your legislation will make?
Sure. Well, I think, as I said, that these crimes extend far beyond aggravated assault and do warrant a term of life imprisonment. However, because of legal ramifications that would follow from that, perhaps the committee will have a problem with that suggestion. And so if the term of sentence was changed, if it was reduced, vastly reduced, say it was put to 14 years, that's something I, in fact, would accept, because the difference would be that the victim's experience would be acknowledged. And that is absolutely crucial. Sentencing is not only about punishment, it's about helping the victim overcome what they've been through, the experience that they've dealt with, their ordeal. And I think on that basis alone, in fact, that we need to acknowledge the suffering that has taken place and recognize exactly what Adorno said. If suffering is allowed to speak, then we have a condition of truth. And on that basis, that is why this bill is passionate. That is why I'm passionate about this bill. But I think it's a way to finally allow victims of torture to have their suffering acknowledged, publicly acknowledged by the body politic.
How much? You actually sound like a conservative.
Oh,
Because,
I assure you I'm not.
Because,
I think he meant it as a compliment.
yeah.
So let's all consider that whatever party your people are part of, it is neither a compliment nor something bad. It's all good.
No observation.
Exactly.
No,
Because
fair enough.
what I'm thinking of is the Victims' Bill of Rights that our government passed in the last session.
Yeah.
And from what you've described to me, that's really the intent of this bill.
Well,
is
the
to-
Victim Bill of Rights, Ted, did not say anything about acknowledging torture in the private sphere.
No, but so you're enhancing the work that the previous government already did.
Sure.
And I understand that, because what you're doing is you're looking at it from a victim perspective, through the eyes of the victim, making sure that it's the victim that should receive priority in the justice system. And I can appreciate that, and I want to commend you on that.
Well, for me, this is a human rights bill that, and I've said this already, a human rights bill that is intent on making a change that acknowledges the suffering of victims, but does so in a way that says that punishment is certainly part of crime. But, you know, the way to create a just society is not by building more prisons, is not by, re-emphasizing constantly the need for law and order. Of course, law and order matters, but how do we achieve law and order in this country and in any democratic society? Criminal codes are absolutely central to that, but when we enshrine human rights principles into the code, then we achieve a more just outcome.
Thank you very
Thank you,
much.
Mr. Chairman.
Good round of questions. Next, we're going to go to Mr. Biddle.
Thank you. Thank you very much, Mr. Chair. Peter, thank you so much for being here. You provided excellent testimony on behalf of victims of torture.
Thank you.
I guess, first of all, I'll allow you to clarify a point, if you like, from our days in candidate school. I know you're a very strong liberal, and I'm sorry.
I believe in the Charter of Rights. I believe in Lester B. Pearson's vision of Canada. Now, Ted was asking very nice questions. Maybe now he doesn't. He's not looking at me in such a fun way. But go ahead.
Thank you. You touched on this, but I wanted to give you another opportunity to describe why it's important for the term torture to be applied to the sorts of crimes that you describe.
Well, as I said, I think it's absolutely crucial that we acknowledge what has taken place. The example I gave before, when I said that aggravated assault is a term that can equally be applied to, and is applied now, to what are acts of torture, but it can also be applied to an instance, a trivial instance, such as a fist fight. That's not my example. That is an example that came to me from speaking with a victim. They told that to me, and that resonated with me a great deal. When torture happens, we need to acknowledge it. whether it is a military official who is acting in that way, or whether it is a private citizen who is acting in that way. These crimes have happened, and we need to acknowledge that they've happened, but we need to call crimes what they are, namely, as I said, for healing to take place.
Are there concerns that your call for life imprisonment puts torture in the private sphere on par with murder, which carries a life sentence? Is that your intention?
Well, the way to answer that, I suppose I could answer that question from a principled perspective. I think philosophically one could make the case that when one is tortured, that crime is on par with murder because the human being is robbed of their humanity, and that is a murder of a certain type, of a particular type. But legally speaking, there are. I think I take your point that if it's on par with murder, and because I've called for a life sentence, but there are other crimes in the code where a life sentence is applied. Aggravated sexual assault in Section 273 falls in that category. Treason, Section 47.1, a life sentence is called for there. And so it's not terribly inconsistent from that perspective. However, one has to put water in wine sometimes. As legislators, I think we all know and recognize that. And for that reason, if the committee was of the view that the sentence ought to be vastly reduced, even down to 14 years, then I would be open to that.
Now, you briefly touched on, I believe, France and Australia, and I believe there's some states within the United States that have similar types of legislation. Are there other examples of that? And I know we've also heard that concerns or detractors of this legislation, that there's concern that this proposed legislation may not meet international commitments. So I was wondering if you could also touch on the fact how France and Australia have this legislation, and perhaps certain jurisdictions in the U.S. and still are within within that framework.
In general comment number 2, the Committee Against Torture, this is going back almost 10 years ago, by the way, recognized that torture in the private sphere qualifies as torture. As I said in my remarks, the Committee Against Torture has a responsibility for monitoring the UN Torture Convention. And so I look at it from that perspective, that if it's okay, if torture in the private sphere is recognized as torture by the Committee Against Torture, then certainly the international legal perspective on this has shifted. So torture, yes, of course, at one time it was considered a state crime, but that has changed. And certainly we see laws in place in Australia and France where torture is recognized. There are American states that have taken action on this as well. A few examples would be Michigan and California. But at the international level, we see Australia and France that have led the way on that. And as far as this legislation goes, it is not reinventing the wheel. It is not reinventing the wheel. There is precedent here. There is legal precedent.
Do you know when France and Australia brought in their legislation?
They've been in place, as far as I know, for certainly in the case of Australia, that goes back about 15 years. And in the case of France, that goes back about 20 years, if my memory serves.
Was there any consequences that you're aware of in the international community for enacting?
No, as far as I know, the sky hasn't fallen. So this has not been the ramifications of those laws have not compromised the international obligations of Australia or France for that matter on the issue of torture.
Thank you.
Thank you very much, Mr. Biddle. Ms. Hardcastle, you're up.
Thank you, Mr. Chair. I guess I'd like to start with just a question, and thank you very much for the background and the work that you've done on addressing the capacity for a private citizen to not only conduct torture, but for another one to have endured it. And I think that brings me to our role and our responsibility internationally. I'd like to hear you talk a little bit more about the optional protocol on torture. The United Nations call for us to enshrine that in the criminal code. Do you think this is an advancement, a step forward for us in that scenario?
I think any time we're talking about punishing torture is something that we can all be proud of. That's torture goes contrary to basic democratic principles, basic human rights principles, and whether it's the optional protocol or a measure such as this, a private member's bill that seeks to make a change to the criminal code, I think that's an important step for Canada.
And I guess on that, then some of the people that have, or some of the organizations that have been speaking up are women's groups, and I just wonder, in the research that you've done in preparing this legislation, why do you think it is that we haven't used a term like torture in the criminal code yet? Like, why is that after all of this time, and as my honorable colleague mentioned with regards to, a victim's bill of rights, why hasn't that been addressed until now that you can see in our legislative history?
Well, I think I know that the definition of torture, because it's been understood for decades, really, from the beginning of when international legal norms around torture were established, it was recognized as a state crime. But the definition, as I said, has shifted. Sometimes, as I think most of you are lawyers, so I don't have to tell you this, sometimes it takes a while for law to catch up. And that's why I think we don't have a crime along the lines of what I'm calling for written into the criminal code. And I wouldn't have anything else to say other than that. I believe, well, perhaps I would. This is about allowing victims to speak. This is about listening to them, and perhaps, and this is a problem in law sometimes, that perspective matters, but we need to shift the perspective sometimes and listen to those who have endured suffering, and perhaps on that basis law can change.
Thank you very much. And next we have Mr. McKinnon.
Thank you, Chair. I'd like to carry on talking about the international implications. One of the government's concerns about this bill is that creating the offence of private torture could seriously weaken Canada's contribution to the global effort to prevent torture under the Convention Against Torture. This seems to derive from the creation under this act of two categories of torture: a state actors as well as private. Would you like to comment on that? And also, why have we got two kinds of torture in this act? Why not just encapsulate them all in one category?
Well, the way I would respond to that, Ron, is to say that if Canada would be in contravention of international legal obligations, then so too would Australia and France. And aside from why, in terms of your the second part of your question, why two charges? Why can't you simply merge them? Perhaps that's an issue that the committee could look at. But we do have established legislation in Section 269.1 that deals with state offenses. But there's another aspect. Torture can take place in the private realm as well. And on that, with that in mind, I think it makes sense to have to look at this in a more complex way. The world is shaded in gray, as I said before. We can have torture that takes place on the part of, it can be a state crime, or it can take place in the private domain as well. And that needs to be acknowledged. Hence the view that we should have two understandings. If you wanted to merge them, perhaps this is something that the committee will discuss.
So I think the concern here is that Australia and France, they have a single definition of torture.
They do, yes.
Whereas the concern here is with two definitions of torture, that will cause problems for us internationally.
Well, no, respectfully, I would disagree with you. Okay. There is one definition of torture applied in Australia, and one definition, and I should be clear, it's Queensland, the state of Queensland that has this in its law. And as far as France goes, in its criminal code, it's merged. And so, again, they're not in contravention of their international legal obligations. No one has ever suggested that.
Well, I'm not suggesting it either, but I guess the government's position is that if we have two versions of torture, that we would be in danger of doing so.
I don't think so, because you'd have to look at the Committee Against Torture report in General Comment Number 2, where acts of torture in the private realm are acknowledged as crimes. And the committee has never suggested that if there is 2 laws, then that would somehow compromise the obligations of a state.
I can fully accept that private acts of torture should be recognized as torture, but the definitions of torture are different in these cases. Apparently, it seems that the definition of private torture is more restrictive, more narrow.
Well, I'm glad you asked that question. I've brought copies. I'm glad to distribute at the conclusion of my remarks. It's a suggested change, and it would line up the definitions. The only difference would be that in Section 269.1, where there's mention of officials, that obviously acknowledges the state element. The law that I'm calling for would simply take out the word official and generalize it so that individual citizens would be liable for punishment if they carry out torture.
Okay, thank you.
In the private
Do I
realm.
have time for one more? Yes. There's also a provision for extraterritoriality in this bill. I'm wondering why you included that and if it's important. And I'm also wondering if someone tried in a foreign country for an offense, could also be tried in Canada for the same offense, whether double jeopardy could apply in that case.
No, I think if you look at that, it doesn't deviate from Section 269.1. I consulted with experts in the law, in a parliamentary council. This is a law that would apply to Canada, and if there are further concerns around that, then it's up to the committee to respectfully look into that and make suggested changes.
Thank you.
Thank you very much, Mr. McKinnon. Before we move to the second round, if my colleagues would permit me, I'd like to try to tie up something that I think Mr. Falk was asking, and I think it has come out a couple of times. So, Mr. Fragascatos, my question is, in terms of adding this provision to the criminal code, is there a class of people that you believe could be tried under the torture provision that you're proposing to add that could not otherwise be tried under another existing provision of the criminal code? Meaning, could there be somebody who now we cannot try and prosecute for their actions that would be torture, but now, as a result of adding this, could be prosecuted? And secondly, if that's not the case, I understand the whole issue of victims that you've brought up and the feelings of victims, but given that the torture offense is a harder to prove offense than assault, do you believe prosecutors would actually use the offense of torture that you're adding when it would be a more difficult to prove offense?
I know that they would use it because I've spoken to Crown attorneys that agree very much with this suggested change. And so I'd see no challenge in that, no difficulty in that regard.
And would there be anybody that could be prosecuted under this offense that could not otherwise be prosecuted under an existing offense?
Well, they could be prosecuted under aggravated assault or kidnapping, but as I said before, that does not match with the experience of those that have endured the violence.
I understand.
Yeah.
All right, so now we're going to move to the second round of questioning, and we're going to start with Mr. Fraser.
Thank you very much, Mr. Chair. Thank you, Mr. Fragascatos, for your testimony today and your excellent presentation.
Oh, thanks.
Really appreciate the work that you've put into this and your thoughtfulness.
Thank you.
I want to pick up on something that you were just discussing with the chair. My question was regarding aggravated assault, and the way it's structured now, it seems as though that torture may be a higher threshold to meet than the existing offense of aggravated assault. Based on what you're saying, with the new offense, then would you consider that aggravated assault would be an included offense with regard to torture? Would you say that somebody could be charged both with torture, as you see it, in the private realm, as well as aggravated assault for the same transaction?
Well, individuals are charged with multiple in multiple ways. That's common. But torture is a higher threshold of violence. We're speaking about a very specific crime, and when that happens, and it's admittedly and thankfully a rare occurrence, relatively rare at least. But when it happens, we ought to acknowledge that it's taken place.
Okay, so somebody could be charged both under 268 and the new 268.1?
I'm not a criminal lawyer. However, individuals are charged with multiple offenses on a regular basis. And so, yes, they could be charged with both, and at least that's my understanding, that's my reading of the law. However, it's not aggravated assault. What they've been through is not aggravated assault. It is torture. And I take my cue from the victim's experience in this. I think we ought to call crimes what they are. I know that there are concerns. Mr. McKinnon raised some concerns about our international legal obligations as well. Respectful disagreements happen all the time between members of parliament and colleagues, and folks around the table could have issues with this bill. It's up to the committee to examine that in good faith, and I know you will. I've put forward my view on this, but to get back to what you were saying, Colin, I think that as far as this goes, torture committed in the private realm is a relatively rare offense that could be applied and more really mirror the situation in a much more just way, legally speaking.
Okay, and just picking up on that, looking at the cases, the past cases, for example,
Sure.
These folks were charged with aggravated assault in the examples that you gave, I presume?
There was a charge of aggravated assault applied. I could go through the examples again.
No, you don't need to do that.
Yeah.
But you mentioned then that it was the prolonged aspect and the fact that judges were mentioning
Exactly.
torture, but they were not able to
apply it. Apply the term.
But
Formally.
you weren't satisfied, by the sounds of it, with the sentencing result.
No, and I don't think anybody would be who believes. I think that the sentences applied were not long enough. But judges who wanted to apply the term torture and did in their reasoning cannot formally do so because there isn't an offense in the criminal code that would allow them to do that.
Okay. I want to move on to what was talked about earlier with the experiences of other countries, and appreciate you said in Australia, I think it's in the state of Queensland, where they have
Sure.
torture provision. Do you know how it's worked there? I assume this is a rare prosecution, that would be a fairly rare thing. Do you know any specifics on how it's worked there, or how many people have been charged with torture, what the conviction rate is, for example?
As far as conviction rates, no, I don't. I can't give you that. I've consulted on that with academics based in Australia who have said that this has not compromised Australia's international legal obligations. But as far as the conviction rate, I can't give you an exact conviction rate. It has been applied. The offense has been used. It has helped to acknowledge the suffering of individuals who have endured great violence, and the same is true for the French example.
Okay. And with regard to the victims, in some of these circumstances, I would imagine that it occurs in a domestic violence realm. Can you talk a little bit about how you see this bill addressing issues of domestic violence and what you think it will do to help the public perception of preventing domestic violence?
Sure. In my comments, I made mention of Megan Walker. Megan Walker has been a tireless advocate for women's rights in my community in London, Ontario, but across the country. When I was consulting on this bill, she told me, she referenced domestic violence, and she has come across so many different cases in her, I believe, 30-year experience as an advocate where aggravated assault has been applied or charges along those lines, when torture actually is in fact what took place. And I think that if we're talking about creating a just society, we do have a just society, but if we're talking about creating an even more just society, we need to recognize that torture in the domestic realm does take place, that women are the victims in so many of these cases. I mentioned before the various organizations that have come out in favor of this bill. There are many women's organizations. The Canadian Federation of University Women, the Native Women's Association of Canada are just two examples. The London Abused Women's Centre on a constituency level has strongly endorsed the bill. And I'm very happy you asked about domestic violence, because I think this would properly, or help to properly acknowledge some of the suffering that women in this country have endured.
Thank you very much. Wonderful work you've done here, and a lot of thought. I hope you won't allow it to be watered down. I appreciate it. I think, first of all, I just want to say I find it immensely ironic that we're discussing your bill today, considering that at the same time we're discussing an extradition treaty to a country that openly and happily seems to torture and execute its citizens. That being said, have you given thought to, I think Mr. Falk brought it up, have you given thought to the minimum sentencing in regard to your bill, or was it only the maximum?
When
I'm
I
also going to split my time with Mr. Nicholson.
Sure. When I put forward I explained already why I put forward a suggestion of life imprisonment. However, there are a lot of lawyers in the room who could look at this and think of an appropriate penalty. I would even say, and I repeat this point because I think it's important, if you were to take it down to 14 years, and therefore allow the bill to be more legally palatable, then I still think it's a just change, because it acknowledges the human rights abuse that has been experienced.
Yeah, I agree with you on that. As I say, I hope it will not get watered down to that. I believe in a lot of what you're saying, and especially with the victims' rights groups, it's very important. I'm quite happy with the 24, with the life. I'm just wondering, was there any consideration? I know you've put a lot of work into it, and you've a lot of great answers. Have you put considerations into a minimum?
No, I haven't, but
Okay,
that
that's
is,
all I'm asking.
14 years is, if you wanted to take it down to 14 years. Yeah.
He's asking you about a mandatory minimum amount. The 14 years is the maximum sentence, or the life is a maximum sentence. He's asking you, have you considered
No.
a mandatory minimum amount?
No, and if you're noticing that I'm evading the question, it's because I'm trying to be polite. I don't believe in mandatory minimum.
Okay, that's fine.
That's an answer.
Very good, yeah. Well,
We like frankness at this
diplomatic.
committee. We don't beat around the bush here.
When you're presenting a private member's bill, one is trying to be diplomatic, but I do not believe in mandatory minimums. But there you have your answer, Kelly.
So I take it you didn't support the Life Means Life bill yesterday?
Oh, you saw how I voted, Kelly.
I didn't actually.
Oh, okay.
So I think that's a no. You didn't support it. Okay. Again, it's a day of irony.
Or Mr.
I'm
Nicholson.
done with my time. We'll
Mr.
pass on to
Nicholson?
Mr. Nicholson.
Well, thank you
Welcome
very
back.
much. Well, thank you very much. And listen, I apologize for not being here at the beginning of the committee, but myself, Mr. Cooper, and Mr. Rankin from the NDP were all in the House today on the motion that's before Parliament here with respect to Atlantic Canadian judges on the Supreme Court. So I actually didn't hear what you have to say, but what I thought about it, and I think you've addressed it, so I apologize if you're repeating again. I mean, there is a concept in our justice system that the worse the crime, the higher the penalty. And so there has been some discussion that if you put a life sentence for torture, that as terrible as torture is, generally what in our system of law, to murder somebody is even worse. And so you would consider reducing it from the life. Again, you may have said that, and
Yeah.
I hear it just raised here, but I don't know that you would be doing.
I would consider that. I would consider that. It's up to the committee, of course, to discuss that, but I would be open to that.
All right.
Yes. Yes, I would be. And as far as I gave other examples of, justifying why I put forward a suggestion of life imprisonment as a punishment, perhaps that was making a statement, and I'm proud to have done that. There are elements in our criminal code where murder is the punishment for that is life, but the same applies for treason as well in Section 47.1. So there's a complex discussion to be had around that. But I think the statement that I was putting forward is to really condemn the human rights abuses that have been perpetrated. But you're right, I've addressed it. I'm willing to take it down.
That's excellent news. you addressed this slightly, I think just as I was walking in. Sometimes we use terms that make our laws consistent, either with other countries that we deal with or consistent with treaties that we've signed. I mean, I'll give you an example. There were people when I was Justice Minister who suggested that we should change the term from child pornography to aggravated sexual assault against an infant. Part of the problem with that, as I saw it, was that there were a number of countries, and they all use the same term, you see, in terms of exchanging of information, you know, whether you're talking with Britain or Europe or the United States or Australia for that matter, they all would use the term child pornography. And so if we had a different term for it, and we're asking because, as you know, in this day and age, we have to have cooperation. There has to be shared information. If we have a slightly different name for the crime, that would raise another issue that possibly could be in court. You're getting information on one thing, et cetera. And so we didn't change the name, and it continues to be known as child pornography. I thought about that when I first read your bill with respect to torture. There is, you know, the United Nations, of course, and there's a certain definition of torture. Now, this intends to expand that, and, you know, we all agree that the terrible circumstances that you have described and what this bill seeks to address certainly address that. But I was interested in your comments. I think that Australia is now using the term torture, and they use it for not just the United Nations definition of a state-sponsored infliction of torture. And so it would be interesting, I think, for us, Mr. Chairman, if there is some legislation and or cases in Australia to that. And was there any other jurisdictions? Did you say France?
To be absolutely clear, it's the
outside of the traditional definition?
It's the state of Queensland in Australia that uses that. It's still important. And France is another example.
They use the term torture.
Yes, indeed. And I want to thank the Library of Parliament for helping me do that research and digging that up.
In terms of Mr. Nicholson's suggestion, the subcommittee, when we met for our next group of witnesses, did seek to find a comparative law professor that would also talk to us about other states that use torture for internal domestic non-state actors.
That's good.
And we are researching exactly the questions. There's some U.S. states that do this. There's Queensland, there's France, and a couple of others. So we're seeking to find that out.
I think that would be very helpful.
Agreed, sir.
Thank you very much. And again, I apologize that I wasn't here to hear
that's fine.
your earlier comments.
They were excellent. Ms. Khalid.
Thank you, Peter, for coming in today and making this presentation.
Sure.
It's definitely
Glad
been an interesting one. My line of questioning is specifically, I'm very glad that women's rights and abuse was brought up earlier by my colleagues here. And you had mentioned from the get-go that the reason that you're so passionate about this bill is because of the impact on victims and in having that crime being called as such. If it was torture, that it should be called torture. Now I noticed that in the drafting of the bill, there is extra elements, or there is a higher burden with respect to proving whether a torture occurred or not, that a prosecutor would then have to show in court. And we already acknowledge in the justice system, women specifically and vulnerable peoples, they go through a lot of stress in getting through the justice system and really trying to get those to get a conviction. Victims, I think, suffer a lot in the courts. So do you think that this extra element with respect to proving that torture occurred, how does that impact a victim in comparison with what you wanted the outcome of this bill to be?
As far as why the definitions don't line up completely, that came as a result of consultation. The view was that since there is a state torture law on the books in Canada, that my proposal would have to differ from that in some substantive way, in some meaningful way. If it's created a higher burden, then that is obviously problematic, and it will be up to the committee I hope to look at rectifying that. I will be distributing, as I mentioned before, a suggested change that I think overcomes that problem.
Do you want to talk about that change now?
Sure, I can read it if you like.
Thank you.
Okay. So the, and you will see it, it will be distributed. You will see on page 2 when it's sent around that, actually, let me do it this way. Let me read, if I can, 269.1, so we're all on the same page, and then I'll read the proposed amendment in terms of the torture offense. So 269.1, which is part of our criminal code, every official, and perhaps maybe the clerk could distribute it.
If the clerk can distribute, then you can just read
Right
the
now.
proposed amendment, if that's
Right
okay.
now would be best. So the existing torture law says every official or every person acting at the instigation of or with the consent or acquiescence of an official who inflicts torture on any other person is guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. That is the existing law. That's how the existing law reads. So in my proposed amendment, I say, I'll just wait until everybody has a copy.
And
I'm
just
glad you
to
asked the question because I
clarify,
wasn't sure if we were going to have time to deal with my proposed change, so thank you.
No problem. Just to clarify, my question was specifically the difference between aggravated assault and the proving of that versus your proposed, proving torture under your proposed.
It's a more specific offense, but that acknowledges the fact, and it is a fact, that torture takes place. It's relatively rare, thankfully, but when it has taken place, and when, let's think of the standard understanding of torture, it's the imposition of severe physical or mental pain onto another human being. When that has happened, then it needs to be acknowledged, and if it has happened, then it's up to the Crown to provide or gather the evidence that that would allow for the offense to be prosecuted. But if you look at, in terms of burden of proof, you pointed to a potential problem with how the bill was originally written. I've made a revision, and so if you compare page 1 with page 2, I've dropped the word official, basically, so that we're dealing with a generalized torture offense that applies to every person.
So what you're saying is that somebody who may or may not have been a victim of aggravated assault could now potentially be charged with torture as well, by making it more broad?
Can you say that again?
So somebody who was, say, punched a couple of times in an aggravated manner,
Yeah.
would now, having broadened the definition as your proposed amendments to your bill, now would that make more people be able to be charged with torture?
No, because if you look, if you follow the onto page 3, clearly defined is that torture is carried out for the purposes of obtaining from the person information. It's or for intimidation or coercion, and it's clearly set out as the imposition of severe pain or suffering onto another human being. And so it matches exactly with the understanding of torture in 269.1.
I just would like to clarify now for the committee, because we've just been past this proposed amendment. So, Mr. Fragaskatos, can I just understand now, what you are proposing that is an alternative to the bill that is before us, that you were suggesting that we simply amend section 269.1, subsection 1 of the criminal code to remove the requirement that it be an official or somebody acting at the directorate of an official, so as that you have a consistent definition of torture throughout the criminal code for public or private acts, and as such deal with the international obligation, so-called objection of a differential definition? Is that what you're now proposing?
It's up to the committee.
Do?
You could go down that road. However, if it's the committee's view that would indeed pose a concern about international obligations, then I have I propose 269.2, which would be a torture offense applicable to the private realm. It's basically the same wording, except that if you look at the first paragraph of the amendment.
I understand. My question for you, I guess, is I understand you're doing this to deal with the so-called objections of having differential definitions and international obligations.
Right.
My question for you is this now your preference of what the committee do, or is your preference the original bill that we were discussing?
This is my preference now. Yes.
What we just score-handed?
Yes.
Okay.
Yes. Yes, indeed.
So if everyone is now understanding that,
I'm sorry if that wasn't clear before.
We'll take cognizance of the fact that this is now what you're proposing.
Sure, and I'm sorry, I just assumed that was because I handed it around and it said proposed amendment. So certainly this is my this is what I'm okay with. This is my view.
Okay. So basically, it's an essentially identical definition to 269.1 with an identical sentence, except for the fact that it is not at the behest of or done by an official.
Exactly.
Okay.
Exactly.
We're going to move to the Conservatives' round of questions to see if Mr. Cooper or Mr. Falk have anything. Mr. Cooper?
Thank you, Mr. Chair, and thank you, Mr. Dragiscatos. Unfortunately, I had to be in the House, so I missed your presentation and missed all the questions up until now, so I hope I'm not too repetitive. But it goes without saying that although there's no specific criminal code provision other than 269.1 that expressly refers to torture, that torture, depending on the scope and nature of the act, could fall under a whole series of different sections of the criminal code, whether it be forcible confinement or kidnapping or aggravated assault. And those various sections are routinely used. The tests are clear. The case law is well developed. And perhaps you could explain where the void exactly is in the criminal code that would form the basis for your private member's bill.
Sure, no problem. I think if you, and it's perfectly fine that you were in the House, you were doing your job. You ask a very good question. If you were to go back to the minutes after today, you will see exactly how that question was answered at the outset. You can, Mr. Falk was, I think, the first person who asked me that question. I quoted Theodore Adorno, the philosopher, who said that the condition of truth is allowing suffering to speak, and that when we apply terms such as aggravated assault, we're not allowing suffering to speak. If torture has happened, we ought to call it torture, because that reflects the victim's experience, and once that happens, meaningful healing can take place. That is how I answer that question.
Now, I just want to ask, and perhaps you've already addressed, because again, I haven't had a chance to go through your proposed amendment, but another concern that I had and I raised when I spoke in the House on your private member's bill was the difference in terms of sentencing under C-242 and Section 269.1 of the Criminal Code. Under Section 269.1, the sentence is up to 14 years imprisonment, whereas under your bill, Bill C-242, it would be life imprisonment. So arguably, you would be creating two different tests, two different standards, and two different sentences depending on whether the act was carried out in the state context or the non-state context. Have you been able to reconcile that issue?
Michael, if you, when you have more time and have the and examine the amendment that I proposed, you'll see that 14 years is what I'm okay with. The call for life imprisonment, some have asked me, was that a statement? Were you trying to make a statement with that? I suppose perhaps I was, but I still think that kind of an offense is, and I would say the same for state torture. When torture happens, whether it's by a state official or carried out in the private realm, I think it warrants a discussion as to punishment, and I think life imprisonment is appropriate. However, to deal with some of the concerns that exist from a legal perspective, I would be open to an amendment that would take back the punishment to 14 years.
minute?
Another short time if you want to.
Well, just a short question, and,
Sure.
and it's a broad question, just dealing with the question of certainty. I guess there is some concern about the uncertainty of the test that, I mean, this is a new test, in essence, under your private member's bill. So perhaps you could comment on some concern about the uncertainty in terms of applying this new section of the
Sure.
criminal
Well,
code.
as for certainty, I would say it's up to the courts to determine if an offense falls within the definition that's proposed, then that test has passed. I'm not sure what else to say on that. If an act of torture has taken place, if it is found that an offender has carried out a crime that matches with the definition that is proposed, then it should be provable in court. And I don't think it creates any negative consequence from a legal perspective. I don't think it causes a burden issue at all. But that's my humble perspective, colleagues. I've enjoyed the back and forth. I really have. But that's a humble perspective, and you're free to debate it between yourselves whenever you like.
Thank you very much, Ms. Hardcastle. Do you have anything further? Your round. And then that'll be the last round for Mr.
Okay, I guess then just quickly, just in light of the amendment, and I appreciate that everybody's getting their heads around it, and I don't have the continuity of being at the past meetings, but let's just maybe take another minute. So, what's the difference if I'm saying that we're expanding the definition of torture, or if I'm saying we're adding it to the criminal code, we're adding private torture to the criminal code? Is it the same thing, essentially, or is there a nuance that you're trying to...
I propose 269.2 as an amendment because there could be concerns around Canada's international legal obligations. And if you were to merge the two, perhaps it could create some issues, although France has done that, and there doesn't appear to be a problem. But it's up to the committee to consider. This is my humble suggestion. This is an amendment I put forward in good faith. It comes from a good place. If it's the view of the committee to look at 269.1 and provide a generalized definition, then it would match with what exists in France. It would match with what exists in the state of Queensland. And granted, it is a state, but it does have international obligations as well. And then you would have, and there's obviously precedent there. And I don't think Canada would be really condemning itself in any way. But that is my humble view, and you're free to again debate it. I'm trying to be as careful as possible in dealing with the concern around international legal obligations.
But I think that for Ms. Hardcastle, for clarity, what was happening was a new section was being inserted as 268.1_1. And in that section, there were subtle differences between the definition of torture and some of the wording than there was in 269.1, subsection 1, the existing section, which related to public officials and people acting at their behest. So Mr. Fragaskatos is now proposing that we simply replicate the language of 269.1, subsection 1, creating again a new section on private acts, but there would be no distinction in language other than that we'd be taking out the requirement to be done by a public official.
That's correct.
Did you have any other questions, Ms. Hardcastle?
Oh, no, I'm good. Thank you.
So, Mr. Fragaskatos, I want to thank you for first being our guinea pig. You're the first member of Parliament that's been here as a private member presenting a private member's bill. So we've all practiced on you, and we all know now how to ask our questions in a better way. But we very
I think
much
the questions were excellent, and I've quite enjoyed my time here. It really is an honor to speak with colleagues.
We appreciate your very articulate and well-reasoned explanation, and I want to thank you so much for both bringing this bill and coming before us today. And now we're going to do a brief break to let our next group of witnesses come forward. So thank you again, Mr. Fragaskatos. And we're going to do 2 minutes. So be back in 2 minutes. And Ms. McDonald and Ms. Hanson, if you could come up, that'd be great. Going to reconvene our meeting of the Standing Committee of Justice and Human Rights in the study of the proposed private members bill, Bill C-242. We're honored to have before us two of the seminal writers in this area in Canada. I'm pleased to welcome Linda McDonald and Jean Sarson, who are here to testify. Ladies, over to you to make your opening statements, and welcome.
Thank you. I just wanted to say first off that Jean and I really support the bill, and we thank Peter for bringing it forward. It's an important piece of work. And the three recommendations that we have in the brief that we submitted to the committee, here's the copy of our brief, or that we would agree with the 14-year sentencing. And we think that naming of torture is really crucial. We want to maintain the naming of torture, and that this bill would not be symbolic. It would certainly be a concrete example of supporting human rights and legal rights in this country, and that intellectual disability does not always happen with torture, non-state torture. May I first say that Jean and myself come today carrying the voices of many invisible persons in our country, persons who have endured non-state torture or torture in the private sphere or private realm. Our testimony is based on what we have learned from their courageous voices. We have been advocating for 23 years for their human and legal rights. We are community health nurses, non-state torture-informed counselors, listeners of non-state torture atrocities, human rights activists, international lecturers, educators, writers, members of the NGO, the Canadian Federation of University Women, mothers, grandmothers, and proud feminists. Jean and I live in Nova Scotia, and in 1993 began a small private nursing practice where in August of that year we met the first woman we came to know as a survivor of non-state torture. Since then, we have provided complex support to 34 persons, mostly women. We have listened to and supported over 1,000 Canadians who have endured non-state torture and approximately 4,000 worldwide, from the US, the UK, Western Europe, the Philippines, Australia, and New Zealand. The persons from Canada are Canadian-born. The majority endured non-state torture from infancy onward. That means they were little babies. Some married their torturers. Some were their roommates. The majority were trafficked, were forced into non-state torture pornography filming, or they were prostituted. The perpetrators of non-state torture are the everyday person, such as parents, extended family, family friends, guardians, strangers, spouses, human traffickers, pornographers, pimps, and johns. The children are groomed to endure torture as perpetrators pay money, knowing they can harm children who can withstand non-state torture. Bishop Raymond Leahy from Nova Scotia was jailed for possession of child pornography, and a file labeled child torture was found on his computer. Non-state actor is a term used by the United Nations, and perpetrators who are non-state actors inflict torture in the private sphere. Key defining elements of torture are that it is intentional and purposeful to inflict severe pain and suffering, with the ultimate goal of shattering the person's relationship with themselves. To give you a better sense of what we mean by non-state torture and the brutality and the gravity of the harm, I will read Lynn's story, a woman born in Nova Scotia that Jean and I supported. Sadly, Lynn is now dead. This story was published in the Journal for the Canadian Centre of Victims of Torture. I was called bitch, slut, whore, and a piece of meat, stripped naked and raped, broken in by 3 goons who, along with my husband, held me captive in a windowless room, handcuffed to a radiator. Their laughter humiliated me as they tied me down spread-eagle for the men they sold my body to. Raped and tortured, their penises and semen suffocated me. I was choked or almost drowned when they held me underwater, threatening to electrocute me in the tub. Pliers were used to twist my nipples. I was whipped with the loop wires of clothes hangers, ropes, and electric cords. I was drugged, pulled under by my hair, and forced to cut myself with razor blades for men's sadistic pleasure. Guns threatened my life as they played Russian roulette with me. Starved, beaten with a baseball bat, kicked and left cold and dirty. I suffered 5 pregnancies and violent beatings, forced abortions. They beat the soles of my feet, and when I tried to rub the pain away, they beat me more. My husband enjoyed sodomizing me with a Hermit 827 wine bottle, causing me to hemorrhage, and I saw my blood everywhere when I was gang raped with a knife. Every time his torturing created terror in my eyes, he'd say, "Look at me, bitch. I like to see the terror in your eyes." I never stopped fearing I was going to die. I escaped, or maybe they let me escape, thinking I'd die a Jane Doe, on that cold November night. And further to this, I can share a questionnaire we ask persons who contact us to complete. Bear in mind that the list of harms are not endured in isolation, as many women tell us they suffered most harms all at that same one moment in time. So this questionnaire is something that we send out to people that contact us to try to help them to see if indeed they could be a non-state torture survivor. So we have forced and drink withheld, chained or handcuffed to stationary objects, savagely and repeatedly beaten, kicked, hung by limbs, burned, cut, whipped, fingers and toes and limbs twisted, tied naked for prolonged periods, forced to lie naked on the floor, confined to a dark enclosed space or crate or box or caged, electric shocked, forcibly aborted, forced to eat one's vomit, bowel movements, raped by one person, raped by a family group, raped by a weapon such as a gun, raped with animals, prevented to use the toilet, smeared with urine, feces, or blood, forced under cold or burning hot water, placed in a freezer, near drowned when held underwater in the tub, drugged with alcohol, pills, injections, choked, pornography pictures taken, forced to harm others, forced to watch pets being harmed or killed, threatened that this will happen to you if you tell, called derogatory names. And in most cases, sadly, I can tell you that the majority of people can list off most of these that they've endured. So that's a high standard of intention of harming. Now, the evidence of non-state torture occurring in Canada is not new. There are government reports dating back as far as 1979, noting the torture women in this country endured. In this report that we sent to the Minister of Justice, we have documented all of the different government reports starting in 1979 that name that torture happened to women. The first one was on pornography and its effects on the survey of recent literature. In 1985, there was a written report to the Special Committee on Pornography and Prostitution. It mentions torture. In 1987, the Canadian Advisory Council on the Status of Women booklet talks about torture and mutilation of women. In 1991, the War Against Women was the first report of the Standing Committee on Health and Welfare. It talks about a husband who tortured his wife. In 1993, Changing the Landscape, torture was mentioned, and we spoke with persons involved with the report, and also the report itself mentions torture happened in every region of Canada. In 2010, The Forsaken by Mr. Opal talks about the right not to be subjected to torture. In 2010 again, Missing Women Investigation Review, Donald Baker talks about the torture of women in prostitution. In 2013, the report on domestic and human trafficking, it talks about, with the RCMP report, it talks about victims who are also reporting torture tactics. And in 2014, in the report by the Native Women's Association of Canada, torture is mentioned many times and talks about torture is torture. So this is what we know as a country about what's happened to torture and women in our country. Our fundamental point supporting Bill C-242 is that presently there is a patriarchal divide creating discrimination between persons who endure state versus non-state torture. The ordeals of torture are the same, yet 269.1 of the Criminal Code only names state torture, leaving non-state torture to be misnamed and minimized as assault in Section 268. Jean and I have estimated that a woman who we will call Sarah, who was tortured and raped since infancy, had endured almost 24,000 rapes. This does not include the object and gang rapes or bestiality she was subjected to. Her suffering was not assault. The correct name for the ordeals Sarah was forced to endure is non-state torture, because indeed suffering is not symbolic. In 2012, Jean and I, as members of the Canadian Federation of University Women, gave expert testimony related to non-state torture to the Committee Against Torture in Geneva. The committee agreed with the CFUW recommendation to amend the Criminal Code of Canada to include non-state torture by non-state actors, and I'll just read a section of their report. The committee is of the view that the incorporation of the Convention in Canadian law would not only be of symbolic nature, but it would strengthen the protection of persons, allowing them to invoke the provisions of the Convention directly before the courts. And that's the Committee Against Torture's own words. In 2017, Canada will be reviewed by the Committee Against Torture again, and we have submitted a brief to the Department of Canadian Heritage with the same recommendation to revise the Criminal Code. If Bill C-242 is passed, we can go back to the committee and proudly report that Canada has shown great leadership in human rights by including non-state torture in our criminal code. The alternative is unconscionable. Thank you.
Thank you. Ms. Sarson, do you also have a statement?
Yes, I do.
Okay. Basically, Ms. McDonald, you sort of exhausted the time that I provided. So, for both of you. So, Ms. Sarson, if you could be brief, it would be good.
Okay.
I thought we were here as
You
individuals.
had 10. No, well, my understanding was you were 10 minutes each, but 10 minutes as together. If you're here as individuals, that's fine. But it means we're going to have to really shorten the questions in the question period. Yeah. No, it's fine. Just go ahead and make your statement. But if we'll just make a shorter question period.
Okay. In reference to naming the infliction of torture, non-state torture victimization causes grievous, destructive dehumanization. Some women described not knowing they were human beings. Some did not know they had physical bodies or skin, or that having their anus hang outside of their body was not normal. These are impacts of repetitive non-state torture, of which sexualized torture is never ending. The severity of non-state torture pain becomes repeated when women's flashback memories surface. Flashbacks transport them into past ordeals, re-experienced at the age they were when they were tortured. They can re-feel the burning and the cutting of their skin, the jaw pain and the taste of oral torture rapes, trying not to panic when feelings of unable to breathe return. They can re-experience their body convulsing to the electric shock, torture memories, re-experiencing the terror and the horror of when, for example, they were 2. So I can shorten that and just go on to say that Sarah, that Linda mentioned, she is 30 years old and she had a master's degree. And when her memories came back, and she talked about them at the age she was. So when she was 2, this is one experience. When she was telling us about it, she said, "It can't go into the little door," meaning her vagina. "The monster," means penis, "is too big. The water is turning color, red color," meaning she was hemorrhaging, "just like the crayons in my coloring book." So what we found is that when women are trying to heal, their memories come back at the age that they endured what happened to them. So the other thing that happens sometimes when they're being water tortured, for example, and they're trying to breathe, the panic sets in, and certainly their terminology we found universally as they go into, they say, we go into the blackness, and we've understood that they go unconscious. So here again, their suffering is not aggravated assault. So under interpretation, I'd like to give you an example of why Linda and I are saying that we'd like to have you consider that in non-state torture, it's not always significant change in intellectual capacity. And the reason for that, I'll give you another example. The youngest person that came to us, she was in her late teens, and she wasn't being believed, and she was accused of being lying, and she was struggling not to kill herself, which is a common response to mental suffering. So she disappeared after a couple years of our support, and then 7 years went by, and out of the blue, we got this email from a friend. "I'm sure you remember Sophie. She will be graduating from nursing school with a master's degree and above a 3.9 GPA. She is happy, enthusiastic participant in life. She told me the other day that she hasn't considered killing herself in a long time. Your kindness and support to her surely helped. I thought you may want to know." So that is evidence that we have to consider exactly what goes on. Now, in reference to some of the questions that were asked of Peter, why it's important to have legal naming. It's a very inexpensive national intervention, and this is Alex, what she has written to us. That when society minimizes non-state torture, it is taken personally and feels like it is me they are looking down on, reinforcing the feeling of how they minimized my worth when they tortured me. Not having the law care enough reinforces what the torturer said. No one will believe you. What makes you think you are so special that someone would even want to save you or care about you? So that was her take on why it's very important. And the other thing around excuse me, naming is that it decreases the social isolation. Many women have told us they feel like freaks because it's not known what they've endured. So that was the other benefit to proper naming. The issue, I think, of the need to toughen the laws and to look at non-state actor torture and keep survivors and children safe. I reference, which you will get, what Jody Wilson-Raybould said, what the mandate letter of Justin Trudeau sent to her and to Ms. Hadou's mandate letter. They were asked to look at these issues. The issue of naming non-state torture happens, that it gives voice to infants, to pre-verbal children, and to older children who are not at this table, whose internet pornographic victimization shows sexualized torture and bondage of newborns and of children up to age 8 increasing, victimized mainly by family and their friends, documented by the National Child Exploitation Coordination Centre, part of National Police Services and Public Safety Canada. And I have some of the data in this statement. And just to let you understand that what we've learned, that people who are responsible for the safety of children, one example they need to know, that stalking and harassment by family-based perpetrators can begin at age 5 when the parents become volunteers in the school. That's a tactic that women have told us about. And that keeps them silent and psychologically captive. Also, in talking to the police, Linda and I have been talking to the police in the last little while, and really they are shocked probably by what we're telling them because they tell us they haven't heard some of this before. So to educate police, they have to know that the crime happens of non-state torture, and they have to know the tools that are used. For example, we surprise them when we say that women have told us that a hot light bulb is used to sexually torture them, if you will, when it's rammed into their vagina as women or as little girls. And just to talk about law that can inform educational sessions, Linda and I were asked by a grade 12 teacher of students who were studying political science, and they wanted us to talk about the political advocacy in this bill, C-242. So the scenario we presented to the students is that they can imagine that they're MPs and they have to study Bill C-242 and decide what and learn about what non-state torture is. And then once, first they started with a questionnaire where they had to decide what they thought the difference was between torture and assault. And I can tell you they picked assault was a lesser crime than torture. And after we taught them, they had to make a decision how they would vote on Bill C-242. So that's what happened, and they were quite dismayed that there was no non-state torture law in Canada and that such a law is not symbolic, and they voted to amend the criminal code. And I guess what Peter has said about Article 5 of the Universal Declaration of Human Rights, that's where we started in 1993 when we were shocked to find out that Canada was not recognizing non-state torture as a crime. And I think for Canadian society, if we are going to be truth tellers, we have to admit to what's happening to children of all ages and adults in this country. I hope that's quick.
Well, actually, you took pretty much the whole time. So I'm glad that you you made it shorter, because I think otherwise you would have gone over your 10 minutes.
Okay.
So thank you very much for it, ladies. Unfortunately, because the Transport Committee was a little slow in clearing out of the room, we're a little bit behind. So I'm going to ask for this round of questions instead of 6 minutes, if everybody will take 4 minutes, so that we can be out of the room at 1 o'clock in respect of the time. Mr. Cooper?
Thank you, Ms. Sarson and Ms. McDonald, for your testimony. Certainly very graphic testimony, I think, reinforcing, if there ever was any doubt about how profoundly evil torture is. I just want to maybe zero in. You touched a little bit in both of your presentations on this, but I would ask perhaps that you could elaborate a little bit. When you look at the criminal code and the fact that we've got various different sections of the criminal code that could apply to various acts of torture depending upon the nature and the scope of the offense, whether it be under kidnapping or aggravated assault or forcible confinement, where do you see the real void as it stands now in the criminal code?
For listening to all the women we've listened to is the naming. If it's not named, they tell us over and over again that that's a void, that it has to be named torture by private individuals or non-state actors.
And we've been told by victims that have gone to court that had non-state or had named torture in their victim impact statement, that was redacted from their statement. They weren't allowed to use the word in court. And we know now from research that when you use a word, it changes your brain. So when you've endured torture and you have to name it something else, then your brain goes in a sense of incongruency or harm. And if you can name something correctly, then it promotes healing in your brain.
Well, thank you. So you would agree then that under the current criminal code, there are not perpetrators who commit acts of torture who are prosecuted under the existing criminal code provisions who are getting off in any way, but rather that to the point of doing justice and making sure that justice is done for the victims and their families, the need to call torture what it is, which is torture. Is that a fair interpretation of your previous answer?
I would say, but I would also say that if we did have a crime of non-state torture in the criminal court, that there would be more people come forward probably with their stories, because I've also been witness to a woman talking to her lawyer about what she had endured, and many of these things that I read about, she talked to her lawyer about, and he said if you brought that in the courtroom, there'd be blood on the floor, your blood on the floor. It's not safe for you to mention those things. And I think that was many years ago. We have evolved, but I do believe that we have to become more open to the atrocities that happen in Canadian homes.
I would just expand that to society. When you said the victimized person, I think every citizen in this country has to understand too. And the law is what helps us understand the culture we live in and the society that is evolving around us. So I think it's a broader context too, that law educates us differently.
That's okay, Mr. Chair.
Thank you very much. Next, we're going to go to Mr. Fraser.
Thank you very much. I'm going to be sharing my time with Bill Casey. So I'll just ask, thank you very much, by the way, for your presentation, for coming here today. Thank you for your 23 years of advocacy on behalf of human rights, and it's really a pleasure to meet you. So I'm thankful that you're here today. With regard to putting torture in the law, non-state torture, you mentioned one of the benefits for the victim, I suppose, is that they feel that naming what they've gone through is somehow a sense of acknowledgement. I'm wondering if there's other benefits of this as well, and I'm thinking in terms of deterrent aspect. Do you think that there's any deterrence that's possible if more people are coming forward, or there's more chance of people receiving a different type of criminal conviction?
I think that prevention would be possible, because the groups that we know, they're very persistent in harming the victim. And if people have children in these families and we access and save the children quicker, the trauma that they'll endure would be much less. So if we have people that will come forward earlier, or healthcare providers or first responders that know how to recognize non-state torture early in the child's life, and we can bring that to court, then the child can be protected, and the prevention of long-term trauma would definitely occur.
And just quickly, the proposed amendment then that was put forward that I saw today from Mr. Fragascatos, you support that proposed amendment?
Yes, I do.
Oh, and you're aware of, you're familiar
Yes.
with it?
Well, just today.
Yeah.
Okay.
It sounds like a good idea.
Okay, thank you. I'll defer to Mr. Casey.
Mr. Casey, welcome to our committee.
Thank you. It's a pleasure to be here. Excuse me. I want to say that Jean and Linda are members of my riding, and I've known them for over 20 years. They are the most dedicated human rights workers in my riding, maybe anywhere I've ever seen. They're so committed and persistent in this cause, but it's not their day job. Their day job is helping the sick and the disabled in Colchester County, Nova Scotia, and this is their. Can't call it a sideline because it's more than that, but I mean they provide a great service in Colchester County in every way. So I just want to make that clear that they are valued members of our community, and we're very grateful for the work they do. But I just have one question, and that is, if this passes, what will the impact be on society? How will it change?
Well, I think society will change in many ways, because if we name a crime, then we make it visible in our country. We start gathering data on the crime. We start knowing how prevalent it is in our country. We have statistics, and then we change the interventions with police and in the court system. We change the interventions with the first responders. They'll understand the suffering that they're witnessing and hear it differently. We'll educate children to know that non-state torture does happen in our country. Like, for instance, Lynn, that was her goal, was that she'd educate young women that the man that she married, she never for a moment dreamt that he would torture her. So young people have to know that that's a reality that can happen in an everyday relationship. So I think it'll make us a better society. I think we'll evolve and follow the recommendations of the Committee Against Torture and be a guiding light in the global community.
You know, as much as you and I have talked over the years, it's over 20 years, hearing your words are hard to hear. When they're in your presentation today, it's hard to hear. And I imagine I'm sure you've had a hard time convincing people in some cases of the seriousness of this torture issue. But anyway, do you have a thought on that? I mean, the words you used today are words that a lot of Canadians have never heard.
I guess, Bill, I'd go to the positive, and this is the Universal Declaration of Human Rights, and I'm surprised how many people in Canada do not even know that it exists in this context. And when we take it to the schools, when we educate in the schools, we do take the Universal Declaration of Human Rights, and we're trying to educate children about equality. And you put it up there and you go to Article 5 and it says no one shall be subjected to torture, and all of a sudden you're having to start saying, well, it's only the people who are state tortured that have that human right. And they're looking at us and saying, how can that be? And we educate different ages in grade 7 and in high school. And in some of them, they take the Universal Declaration and kind of hug it and say, we have something there, but they are questioning the inequality that exists when we don't have Article 5 apply to every person, regardless of who they are in this country. So I would add that. That's very significant in how we change our society, our young children.
Appropriate, and it's good to remember that John Humphrey, a Canadian, was the author of the Universal Declaration.
Absolutely
Former
correct.
law professor at McGill of mine. Very, very great man. Ms. Hardcastle.
Thank you. There's so much for this whole committee to deeply reflect on, and I know you were here earlier. One of the comments I'd like to give you a chance to respond to, just with regards to equating torture and what you've described with someone getting a life sentence. And I I hope you just know what I'm getting at without me having to say it, but it was mentioned earlier about how our sentencing reflects this hierarchy of crimes. And I know that it will be more that this committee will have to deeply reflect on, but, you know, just the idea of torture as equated to murder, the small pieces, however you want to go into it, I would just like to hear you talk a little bit more about how can this actually be named torture, but just have an aggravated assault label on it, but you've just changed the name. Is there something problematic with that? I think that that's a deeper question for the committee, but you heard some of the comments earlier today. I'd just like to hear you kind of respond to that.
Around the sentencing,
around the sentencing issue, and it's not taking away a life. Why should you have a life sentence?
Well, I feel this bill is so important that if members in the House are concerned about the inconsistency between the state torture sentencing and the non-state torture sentencing, I'm willing to let that go. I think it's fair to be consistent. I mean, we can't say you're going to sentence a higher sentence for non-state than state. In my opinion, I'd like to see them both go to 30, but that's another issue. I just feel that the bill is so important to go forward, and if that's a blocker, I'm fine with the 14-year sentencing for both. That's my answer.
Thank you very much. And finally, Ms. Khalid.
Thank you very much for your very moving testimony today. We don't often see the impacts of violence, and I'm very grateful to the work that you're doing with respect to that. Question with respect to your work with the victims. Have the people that you've been working with gone through the justice system, and have their perpetrators have they been convicted with any offense?
No. There are several reasons. Number one, you don't have a law. So if there's no law, they can't go forward and say they've been tortured. And as Linda said, their statements are redacted even if they would try to say something. The women that we have worked with, like I say, that they don't even know they're human beings, so they don't know they have even legal rights, human rights. That's all foreign to them. Many do not have the capacity to withstand what a legal system would do to them until society is open to understanding just the brutality that can exist in relationships. So, no. None of them have come forward for those reasons. No law and no support and no social realization of what they have endured and what the impact is of the non-state torture they've endured.
Okay. The sponsor of the bill had mentioned a few people that had been convicted for aggravated assault. My question then is, having victims that are so sensitive and going through a lot of disabilities with respect to what they've gone through and their experience, and putting those victims through the justice system and having them to now prove an offense that carries a very high burden of proof, how do you think that will impact victims going through the justice system?
Well, the women tell us that they want the bill. They really want this bill so that they can be understood and start speaking fully about the atrocities that they've endured. So if I go to their voices, they're willing to try. And I think if we open our court system up to thinking about non-state torture in the everyday sense and educate lawyers and judges and police and all of us, then we'll evolve through that. But we won't even start if we don't have the law. So I think they're ready.
I have no more questions.
Can I just add a little comment?
Sure.
A little comment to that around the burden of proof. I think we have to start somewhere, and right now There is some proof that infants and young children are being tortured in the pornographic industry. So if we started there, even you start opening up society to the knowledge that such atrocities are happening, because they have the data. You know, at the National Center for the Protection of Children, that's visual data. That's data that the police have. That's the data that this country has. So they can use that. And you could start charging the families who perpetrate, which are the most frequent perpetrators or their friends. You could start charging them for torture, and the burden of proof starts developing easier.
Thank you.
Thank you very much, Ms. McDonald and Ms. Sarson, for coming all this way to testify before us. We very much appreciate you being here. We've listened carefully to what you've had to say, and in the same way we've listened to the sponsor of the bill, Mr. Fragaskatos, and we look forward to continuing our deliberations on the bill at our next meeting, and meeting adjourned.
Thank you.
Thank you.